Hi, everybody. Welcome to our first office hours at Behring Co. First open Q&A sessions where we're engaging with investors, we're engaging with our attorneys, agents, and other people that just happen to have questions from everything that is changing in EB-5. So we wanted to create this once weekly event where people can sit in, open engagement, chat, discussion, ask about policy, projects, how to explain anything, and that's really what today is for.
So just to bring everyone up to speed on current EB-5 policy. So as everyone knows, the law changed in March 15th of earlier this year with the EB-5 Reform and Integrity Act. And a lot of changes came with that act, but at the same time, we had to wait for a long time for USCIS to get things in order for us to actually proceed. And we also had to file a lawsuit to nudge USCIS along to do the right thing. We succeeded in getting a preliminary injunction in late June, and that court order enabled Behring and enabled regional centers across the board to know with certainty that they were not indeed canceled and that they could proceed. And then about a month ago, we obtained a settlement with USCIS where we finalized that preliminary injunction and finalized an agreement that finally established the regional center program on solid ground and enabled EB-5 investors to start filing their petitions right away. So that's what we've seen in the past couple weeks now. We've had several investors already proceed and start filing. Our regional center for our projects, we filed the 956F. We got those in a record five days, and that provided that level of certainty for the investors to go forward. In the meantime, we're changing fiscal years now. September 30th is the end of fiscal year 2022, and we're moving into fiscal year 2023. And at the same time, as this past week, the State Department issued the October 2022 Visa Bulletin. And we're seeing a couple of important things right now. One, in the EB2 category, we're seeing a further retrogression for EB2 for EB2 applicants from India, going from 2014 to 2012. And one of the driving factors for that is the State Department is projecting much fewer visas to be available because the carryover of unused family-based visas during the COVID pandemic when the consulates were shut down, that's pretty much over. We're not going to see that kind of carryover here going forward in fiscal year 23, and certainly not in 24, unless there's some major change, and hopefully not with respect to COVID. The other aspect we're seeing too is in the EB-5 category, we're seeing a retrogression again, as usual, for China, but also for India. And there's a little nuance here, so I want to take a moment to kind of give a little bit background and breaking down this Visa Bulletin chart. What is new here, and that we've seen these past couple of months, but now it's become a reality for folks because we can actually file petitions, is that the Visa Bulletin now breaks EB-5 down into 4 categories. So we're looking at pre-RIA EB-5 investors for both direct and regional center applications, and post-RIA EB-5 investors for direct and regional center applications. So the first row there for fifth category, the EB-5, is unreserved, and that's where you're seeing the visa retrogression. So for India, the visa retrogression starts as of October. For any of folks out there that have already filed their I-526 petition and they're in the United States on a valid visa, then you should consult your immigration attorney to determine if you can apply for your adjustment of status before the end of this month. And if once the October date goes into effect, then you're going to need to see if you are able to file, if your priority date is before December 19th, December 8th, 2019. So if you filed before that date, your priority date is before that date, then you'll be able to file for your adjustment of status. For anyone who filed I-526 petitions after December 8th, 2019, and you haven't filed for adjustment of status and you're in the United States, then you should see with your attorney if in the next couple of weeks you can get qualified to make that adjustment.
Okay, so guys, again, there is a big chat desk on this thing, and there's a very small group of us on purpose here at the office hours. So if you do have questions, go ahead and throw those in there. We're going to collect everything and answer them as they come. Again, if there's only 8 or 10 of us, we can talk to everybody individually. We can even bring you live on the webcam. Go ahead and throw questions into the chat. And then one question that we just got from Samuel, asking like, what is the RIA? RIA is actually the Reform and Integrity Act. That was what was passed in March and then has slowly been implemented and rolled out. There was a whole lot of drama on getting that going. But when we say RIA, essentially that means the new policy. So the new rules, the new set-asides, new TEAs, the new investment amount. In summary, that is the RIA. The old program, 500,000, and like for some people it was 1.8 million and 900,000. Old programs would be pre-RIA. So that's what we mean by that stuff. And what Peter was talking about with the Visa Bulletin here that you see on the screen, the new categories for the set-asides, for things that are urban TEA, for rural, for infrastructure projects, those were categories that did not exist before the RIA. It used to be much simpler. You talked about EB-1s, 2s, 3s, 4s, and 5s, and then all of a sudden EB-5 got itself 3 brand new categories that are set-asides on a go-forward basis. So when you see the Indian retrogression and you see Chinese retrogression on the old category, the 5th unreserved category, that's essentially old EB-5. And then the new EB-5 has 3 brand new categories for the 5th set-aside for rural, 5th set-aside for high unemployment, the 5th set-aside for infrastructure. Those are new categories, and anybody filing an I-526 today would be looking at being as part of one of those set-asides. The vast majority of any really marketable project and a project that you probably want to consider would be one of those that is in the set-aside categories. For example, everyone has probably seen a whole lot of information regarding 1900 Broadway and our current projects. We fall under the high unemployment set aside for TEA. It's urban and high unemployment set asides. So that's where we fall. For the previous investors that are pre-RIA, depending on the priority dates and depending on what's going on, there is a bit of retrogression. And today it looks like it's going back to December of 19, if I'm looking at that correctly. There is still going to be a lot of bumping around from the State Department and releasing these items. And there's even a lawsuit pending trying to recover a whole bunch of visas that would in turn go to those categories. And, Peter, I know you've looked at a little bit of the information regarding the lawsuit. Do you want to explain kind of what they're going after and what their kind of the merit of their case is?
Well, there's a couple lawsuits going on, and I see a couple questions about the retrogression, so I'll address that in a second. But there are actually a couple lawsuits that are interesting that are pending right now. One lawsuit, and these are both brought by the Banias law firm and one in conjunction with Wolfstorff and Banias. One is challenging the retrogression in the EB2, EB3 categories. I'm not as familiar with this lawsuit, but in terms of the merits of the claims, but they are challenging the way that USCIS is implementing this retrogression. The other lawsuit with respect to EB-5 is they're challenging the State Department by trying to prevent wasting unused visas. Due to slow processing times and just inaction, the State Department hasn't allocated visas as quickly as they should have. And we're looking at tens of thousands of several 10,000 of under 20,000 of visas that could be wasted. And we say wasted, they're gone forever, right? So these are visas that are rolled over, that we got extra visas because of the unused family-based visas during the COVID pandemic. Portion of that goes to the employment-based categories, and then EB-5 gets 7.1% of that allocation. So they're challenging that based on the regulations that the State Department is supposed to allocate these visas and make these available, so to prevent that wastage. That's pending now. If they do succeed, then there's a potential of 11,000 visas or more that are going to be able to be used by retrogressed countries such as China, especially followed by India. So this could mitigate substantially any retrogression for the unreserved visa category. The last year, there were over 19,000 visas available in the EB-5 category. Almost twice the normal 10,000 per year. Because it's a fiscal year 2022 with the RIA and the new visa set-aside categories that Colin mentioned, of those 19,000, there were 6,000 or more, around 6,400, that were applied for the reserved category. Of course, no one had an approved I-526E this past year in order to make use of those reserved categories. And so this is one gentleman's question here is, what happens to those unused reserved visas? Now, according to the statute, they roll over. So those unused reserved visas roll over to the following fiscal year 23, and to their respective categories. So the unreserved the reserved visas for rural, high unemployment, or what we still call TEA, and infrastructure carry over to fiscal year 23 in their respective categories. And then carry over again, any unused reserve visas would carry over again to fiscal year 2024. At that point, any unreserved visas would flow back to the general unreserved category. The question that's before us, and this goes to the current India retrogression and China retrogression, is the State Department, if they know that these unused visas are going to be unused for 2 years and most likely roll over, just given processing times for the I-526E petitions that people are just filing now, will the State Department use them to maximize use of available visas and use them in the unreserved visa category, which would then mitigate any retrogression for India and for China? We don't know yet, and we're watching that. And of course, as soon as we get any information from the state and USCIS and how they're implementing the rollover of the reserve visas, then we would certainly let folks know. So it's a little early to tell, how long, for India anyway, how long this retrogression will be for the unreserved unreserved category for Indian investors. There weren't that many petitions filed in late 2019 before the regulation was passed and raised the investment amounts to 900 and for most projects 1.8 million for over a year. And of course, there are hardly any petitions filed after that. So right now, as USCIS is starting to process more I-526 petitions from 2017, 2018, and early 19, we're seeing that those visa numbers being used by India, because there were a lot during 2018. So I don't think it'll be that long, but we'll monitor the situation and let folks know as we go forward.
Yeah, and the data on the Visa Bulletin is a little bit misleading to an extent, because it gives you a date of whatever the processing petition, the last current processing petition would be, but it doesn't actually show you the volumes of when there was the flow of petitions that caused this retrogression. And one of the big items to look at is that, like, historically, with Chinese retrogression and even the EB-5 program in general, is that the January date of 2016 is right after the massive rush that was the first legitimate expiration scare that took place, and there was 15,000 filings in a single quarter, and it created this pig in the python type analogy where all of a sudden there's this huge load of petitions that went in there, caused retrogression for really the first time, and that USCIS was chewing through that backlog. And then, as Peter mentioned, there were multiple events in EB-5 history since that time that were very, very much a lull where there was not many petitions filed. And those dates will catch up very, very quickly once it starts to get past those clogs. So, Chinese retrogression has probably seen that November 2015 date for quite some time as USCIS was chewing through all that. And, with the multiple lawsuits, and then even the potential of the executive branch being able to go recover unused visas that were mandated for use, but lost to whatever inefficient processes by the State Department, there's a possibility that a lot of these dates move forward a lot faster as time goes. But with the new categories in the unreserved, there becomes a couple questions as far as the new policy in RIA, how it's going to be handled with the rollovers and how those visas are going to be pulled over into the future. Does unused infrastructure projects go back to the infrastructure budget? Does unused TEA go to the TEA budget for next year? How they get rolled over? Is there a priority of one over the other if one gets used and over allocated? These are questions that are going to hopefully come out in the USCIS engagement call that I believe is scheduled for October. Yeah. So if you're not signed up for that call, there is a sign up on the USCIS website, or we will try to post that link so people can actually join and listen to that call. But that is supposed to be a legitimate engagement where we actually get to talk to USCIS back and forth, rather than the listening sessions where essentially you sit there, listen to half-baked answers on things that you already knew, and they don't really answer any of our burning questions. This one is supposed to be much, much better. And this engagement call in October will precede our first lawsuit mandated implementation meeting with USCIS. If you guys don't know, part of the settlement for the lawsuit that we just concluded was that there is quarterly meetings about the implementation of our settlement, and we'll hopefully get some answers for functional operational questions in regards to our lawsuit settlement and moving forward. That will also give us critical answers as the new policy has started to roll out. So these are really detailed questions. It's really detailed operational items of how the visa and immigration process works. And we are happy to keep answering questions. If you guys have them, we'll carry them forward, but we'll get to the next topics and other updates. But ultimately, we're going to come back to an open Q&A here in a couple of minutes. But did we get everybody's questions regarding the visa bulletin or the retrogression items?
Well, one question that's kind of related to this topic would just be processing times. And as one gentleman is asking, is whether or not USCIS is meeting its 6-month target for processing the I-526 petition.
That's a good one. Yep.
And whether they're, eventually the I-829 petition for the permanent green card. Now, just to give some context, in the Integrity Act, or the RIA, there is a provision or a section in the statute that requires USCIS to implement a fee study. So they have 12 months from March to implement a fee study to determine how high they should raise the fees for all these forms in order to achieve certain targeted processing times. And it varies depending whether it's a TEA project or rural project or not. And it varies also which form. But generally speaking, they're targeting between 90 days and 240 days to adjudicate and approve these forms based on location and form. So they have 12 months from March to complete this study. And then I think it's 90 days from completion of that study to raise the fees, in fact, to achieve these processing times. So we still have some time yet. It's too new to tell in terms of the processing times for the I-526Es that are being filed as we speak. On the other hand, USCIS in these past couple of months have publicly stated, have publicly posted on their website and in their email and other publications that they're trying to meet these processing times, and they set different targets depending on the form, including the I-526 and the I-485 for 6 months. They also included target processing times for the EAD and the advanced parole, so the work authorization. And I think the target for that was 90 days, if I remember correctly. And we have seen that. So it's too early to tell yet for the I-526 petition and the I-29, but we have seen faster processing times for the EAD and advanced parole. So one of our investors recently got her EAD and advanced parole within 100 days. And so that's optimistic.
Huge.
We're seeing that as getting USCIS getting it back to pre-COVID processing times for the EAD for business employment category visas. And this is relevant for those in the audience or future viewers that if you take advantage of concurrent filing that's available now under the Integrity Act. So here if you're in the United States on a valid visa and you apply for EB-5, then you can simultaneously apply for concurrent filing of the adjustment of status application. And that gives you the ability to apply for your work authorization and your advanced parole. So you're getting the benefits of the green card while you're waiting. Now, this could be useful for folks who are shifting jobs or want to shift jobs, maybe work for a startup that can't sponsor the H-1B EB-2 process, or to form your own business, right? And to just give you that flexibility. So that's a new option available, and we are seeing those EAD processing times speed up.
Yeah, and that includes the F1 student visas, the J1 visas, as well as anybody in the H-1B line. So that concurrent filing is probably the most impactful direct item that goes to the investors as far as the improvements from the RIA. So definitely taking advantage of that, and especially as a massive public service announcement, anybody that is thinking about doing that concurrent filing and wanting to do that immediate adjustment of status, which is something you never had access to before. So all the students that are here on F1s, the H-1B workers, all those people, that only works if you are current under the category that you're filing for. So when you're looking at this chart right now, every single category on the EB-5, the fifth preference, whatever the reserves is, those are all C's. Those are all current. Those are all able to be filed and immediately file the I-485 for the adjustment of status. And then those categories don't include a lot of visas, which means that everyone in the country that is in one of these marketable categories is going to be rushing to get part of those set-asides, the 20%, the 10%, and the 2%. So what that means is that if you have the ability to take advantage of the concurrent filing, and it's only possible if it's current, you would want to do that sooner rather than later, because the data that's in these visa bulletins is lagging data. This is stuff that's already in the past, it's already happened, and these charts will change in the future with no warning, and you'll have no way to know whether we're coming up on that, the cap and the numbers until after it's too late. One of the things that's a little bit serendipitous, and the timing is interesting, is the fact that we now have a new fiscal year. Mm-hmm. So we wouldn't 15 days, actually, if you have a priority date, before 9/30, then the next year will be starting after the end of September. So that's the federal fiscal year starts after September. It's not a January 1st start. Federal government works after September. So we probably beat this one to death, but it's definitely an important topic as far as retrogression, backlogs, and ultimately leading to your processing time. And then hopefully whichever project, whichever professional you're working with has a deep understanding of the visa bulletin and being able to tell you what they think processing times will be. Because if they don't have a mastery of this data that's in these charts, then there's no way to think that that information is going to be accurate.
Just one last, we'll have a Q&A at the end, but before we move to the next topic, just one last point because of a question that came up. The retrogression for India doesn't apply for people who are filing now. So if you are filing now, or next year in 2023, the retrogression doesn't apply to you as we speak. For if I should qualify that, if you're investing in a reserved visa category qualified project, such as 1900 Broadway, that means if you're investing in a rural, a high unemployment, or an infrastructure project now, you are not subject to retrogression. Now, of course, this may change in the future because there are limited number of visas in each of these categories. They are carrying over. These unused visas are carrying over. So I don't expect a retrogression in the short term, but this retrogression you see in the unreserved visa category for China and India currently do not apply to folks that are considering investing now in an $800,000 project.
Okay. So, Peter's better about not using people's names. I'm tempted to when you ask questions, so hopefully people are not offended if I do. But when you hear us start to peel out one of your questions, please confirm with the chat that you're good to go. Or if you want more elaboration, throw things in the chat. We're going to get to it. But to be very, very short and clear about what Peter just mentioned, if you're a new filer looking at the new projects in the reserve categories, there is no retrogression right now. It is current. So if you file 2023 and you do concurrent filing, you're in until this visa bulletin changes. So there's no discussion of retrogression if you're a new filer today and every category is current. So just to be very clear about that question. And then, we have other questions about, can you finance EB-5 investments? Can you do partial capital commitments? Can you do unsecured loans? We're going to answer that in the Q&A, but we do see the question. Yeah, so 956K, big release from USCIS. And I don't think a lot of the investors that we talk to have really given this enough consideration or enough thought and or have given enough credit for what it can and can't do, because 956K is more of a regional center form or a sponsor form. It's not really an investor form, but the implications for the investors are incredibly strong. And this is something that was just released. USCIS finally got it out. But ultimately, this form is driven by the integrity measures. Mm-hmm. The integrity measures and the intent to improve the industry. It is supposed to be an investor protection. And how does it do that? This is entirely based on a follow the money principle. You hear it in every single bad cop movie or FBI research, investigations, whatever. Follow the money, because wherever the big money is flowing, typically that's the most motivated individual that is part of the transaction. And in the EB-5 industry, the idea of intermediaries, agents, brokers, referrers, introducers, like whatever you want to call it, there was always this element where they may have not disclosed who's actually doing what in an EB-5 transaction. So you had people that were financially motivated to do certain things that the investor may or may not knew about. So this I-956K form is supposed to add transparency and daylight the financial transactions tied to your investment, where it's going, and who's getting paid. And if you know who's getting paid, then you know the motivations behind everybody participating. So that transparency will hopefully clean out a lot of bad actors. It'll convince a lot of groups to act with integrity, because having transparency and having everyone be able to look each other in the face and know exactly who's getting what, that will have an integrity impact and will improve the industry. However, there is certain items that may have unintended consequences. So, Peter, if you wouldn't mind, why don't you just comment a little bit about the penalties or the sanctions and what happens if people don't abide by the 956K? Like what is the penalties? Like what are the enforcement mechanisms
Sure.
that they're talking
Sure.
about?
Well, I mean, as Colin mentioned, like the key theme to the Integrity Act is increasing transparency. And we all know that, the EB-5 program historically hasn't been a very transparent industry. There's not a lot of information you can find publicly online except through the USCIS.gov website. And even then, it's not regularly updated. You'll see on the approved regional center list, it was last updated in October of 2021, where it listed over 632 approved regional centers. Based on information that came up during our lawsuit against USCIS, we're estimating it's probably after the full implementation of the Integrity Act, there are probably fewer than 100 regional
Right.
centers, and probably even fewer still as we go forward, because of the requirements and many of these, and cost, and many of these requirements are not really new. I mean, they've always been there from a securities aspect and other aspects, or just best practices. And they really are just best practices that you do see in the top regional centers. With this form, is again, the theme is transparency, because sometimes you will have regional centers that work with immigration agents abroad, or broker dealers domestically, some other kinds of promoters of the project. They're supposed to register now with USCIS, and it's a little unclear to whether it needs all employees that are of these firms, but at the very least, it seems that everyone needs to register, including contact information, and disclosing whether or not they have certain background elements that would not be desirable, disciplinary measures from financial or security regulations,
FINRA, SEC sanctions, anything of that nature. USCIS
fraud.
wants to know.
Yeah. And it's something that regional centers and NCEs, they all have to do this as well, go through background checks and so forth, which is good. They also have to disclose, at least in this form, they have to disclose that there's agreements. They don't have to disclose the fees, but now, later, when you file the I-526E petition, the promoter, the agent, and so forth, they're supposed to disclose the fees that they're receiving in connection with procuring the investor for the project. In terms of potential penalties, right? The regional center is, even for promoters and agents and so forth, the regional center is supposed to ensure that everyone is following the EB-5 regulations and securities regulations, accurately conveying the offering and the project. And the failure to register, the failure to disclose, or other bad conduct could lead to severe consequences, including being terminated from permanent bar from the participation in the program, either as a person or as an entity, and severe sanctions, up to 10% of the capital raised. So
and sanctions is a cash penalty. Like it's a fine where you have to fork up money in order to pay a penalty for violating the 956K and not being transparent about your cost. If you didn't disclose the deal or whatever money's being made off an investor, then there's a penalty. And those sanctions, the penalties, and Peter mentioned terminations. That's really more about regional centers being a part of it, and then the permanent ban would be for any promoters, intermediaries, agents, and or even sponsors, I guess, developers, personnel. Yeah. And those are all investor protections, like, abide by the laws, obey the laws, do the right thing, or get banned. The problem that is a potential snag in this whole calculation is that it creates a potential risk, because say you're working with a regional center or a sponsor, a project, or somebody who, for whatever reason, they did not do this, but they did it on a different investor. They did it on a different project. They did it on something completely unrelated. but they get busted by USCIS or SEC or whoever's essentially enforcing the 956K. Somebody else was the violation. Your regional center gets terminated. All of a sudden, you don't have a regional center, and your I-526 is no longer sponsored by a regional center. And if your developer or the sponsor or somebody's permanently banned, what do you do at that point? There are certain measures in place with the RIA where it allows you to switch regional centers
within 180 days. Yeah.
180 days, which if you're frantically running around in an industry that you don't really live and breathe every day as an investor, you're really depending on your regional centers, your sponsor, and somebody else to be doing a lot of the heavy lifting. 180 days is not the longest amount of time. Plus, depending on the structure of your investment and the sponsor, the regional centers, and everybody else involved, does a new regional center really want to take you on? Like, what do the economics look like of that situation? So long story short, what does it mean and what kind of risk does a new investor take on? You need to be very, very sure about the quality of the platform and the people you're working with, because if they've got a really tough history and a bad history of working with a lot of really sketchy groups raising money and renting out their regional centers and handing out whatever to anyone that's willing to pay $1, they're going to have problems, because a disgruntled ex-agent or employee or somebody starts sending stuff off to USCIS, and then it daylights things that they weren't supposed to be doing years ago. Those operators and those people with bad histories, a lot of that stuff could affect a future investor. And that's why the quality of the firm you pick and the controls that are in place, the reputation and the people is going to matter 10 times more today than it did pre-RIA. And that's why you're seeing less than 100 regional centers exist today compared to the 1,100 plus at the peak, which was, probably 2016, 17, and started to slowly see people leave the industry after that, after the markets really slowed down. So, ultimately, the 956K, super strong on investor protections and transparency and creating really investor protection. But then again, if USCIS comes out and shoots your regional center, you still needed the RC to finish your process. So it's going to be interesting to see those groups and how that gets handled. But ultimately, it is a pitch to know who you're going to do business with, know their backgrounds, how they do business, and that is the kind of personalities and people that you want to be partners with for the next half decade or more. So that's the moral of the story for the 956K.
And just one question on this related to this was regarding to the fees and source of funds. At this point, no, attorneys' fees and like third-party promoter fees, brokers or immigration agents, source of funds consultants, and so forth. USCIS has not clarified that these fees need to be sourced for your I-526 petition. Currently, the prevailing practice is to source the documents source the funds, of course, for the capital investment, and any administrative fee or subscription fee and so forth paid to the regional center or sponsor or issuer of the offering. So no on the agent attorney fees for source of funds.
Yeah, and those discussions on source of funds are like really what needs to be included versus what's not. That has always been a big question mark for a lot of people in the industry, because why does it make sense to have to source X dollars from the attorney's fees or a source of funds consultant, or the administrative fee versus the lawyer fees? It really was a bit of a political opinion on who needs to be sourcing what, and we're going to get a lot more information on during the engagement call with USCIS. So another item that's going to be on the list of all sponsors and investors really wanting to daylight and clarify these items with USCIS going forward. So steps in the right directions. So we'll go straight to our EB-5 myths and misunderstandings. And then we've already kind of dived into a couple of these things. But ultimately right now, all those categories that we just discussed on the Visa Bulletin are all current. It is a free for all right now with a new EB-5 program, new visa allocation. Everybody's got a fair shot at getting started in EB-5. But then investors, when they're talking to us, give us their account as far as, there's rural, urban TA and high unemployment, or the infrastructure. I was told that I have to do rural, or I have to do infrastructure, or, I have to do something. And that right now we need to clear up what exactly are these set asides and what do they mean to USCIS, and what is better, or does it even matter? So ultimately, Peter, do you want to explain the difference between like a set aside and then a priority processing and or expedited? But let's focus on the set asides first and what they mean versus each other.
Sure. So very often, I mean, the actual Integrity Act, or the RIA, creates 3 visa set asides, that they're reserving visas out, they're carving or reserving visas out of the annual 10,000 visa cap each year. That is for the rural projects, the high unemployment urban projects, and the infrastructure projects. The high unemployment is sometimes called TEA, or we still refer to it as TEA, but the definition is still the same as what we saw in the old 2019 EB-5 modernization rule. So that regulation created new TEA definitions. It was later vacated by our lawsuit, but they eventually incorporated it into this act. So when we talk about TEA, or targeted employment area projects, we're still referring to the now what's called high unemployment area projects. And for example, our current EB-5 project, the 1900 Broadway, is a high unemployment urban project. We just still, for shorthand, we still refer to it as TEA. Which one's better? Does it make a difference? They're all have their own lines now, as you can see in the visa category, in the Visa Bulletin. So they're all current, and generally speaking, they will be faster than, at least in the first few initial years, they'll be faster in an overall speed to green card than the unreserved visa category. Because if you're applying in a unreserved visa category, $1 million project, you're going to be competing in line with the pending 14,000 petitions.
That's right.
That are in the unreserved category. So it's clear that the reserved categories are going to be faster, at least for the next few years, until demand exceeds supply for these reserved categories. Now, between these two, you're going to hear a lot of words like priority processing, expedited processing, and so forth. Priority processing does not mean expedited processing. Expedited processing is a petition-based or individual-based. In the past, there were projects that marketed themselves as an expedited project because it had some affiliation with something in the government's interest. But it was always still processed on a case-by-case basis. So in the early days, that expedited project might get more and more of those petitions processed on an expedited basis, but later those times actually extended further and further out as later petitions came in. So it wasn't a guaranteed on a project-wide. Generally speaking, you're looking
one more thing about that. For expedited processing, it is on an individual investor basis, and it can go away. It can expire, and it can disappear. And, depending on how much integrity that group has, whether or not they tell you that the expedited processing is either no longer in effect or expired or has passed, sometimes they'll just leave you to look at other marketing materials and other people's stuff and not take responsibility for it when their project actually does not have expedited processing anymore. And then you're stuck with the underlying process without the expedited processing that you thought you were signing up for. And typically an expedited processing project is either severely economically challenged or in a location that cannot attract capital otherwise, which means that without that expedited processing, there is a 99% chance that you absolutely would not have chosen that project as an investment. So being very careful about what's being marketed out there and verifying the inputs of what they're actually selling and what they claim to be offering as that EB-5 investment project. So unfortunately in EB-5, some of these groups, they're fast moving targets, and the verification, as well as verifying it with your professionals, your immigration attorneys, the economists, and the other professionals that are working on the various deals, they'll tell you right away, what can be verified and what can't.
Yeah, and now like expedited is really more on a personal basis. What we saw in the past were dealt with like personal characteristics of your petition, urgent or emergency situations regarding you and your family.
Yeah, doctors during COVID.
Right. That was the most recent one. We had many of our physicians that are investors in our projects were expedited because of their ability to contribute to the helping people in the COVID pandemic. Another situation was historically when there were the protests and so forth in Hong Kong. Some investors were able to expedite their petition based on that political situation. Priority processing, which is mentioned once in the RIA Integrity Act for rural projects, that's undefined. It's not the same as expedited on expediting your application, but we don't really know yet what that means. And ultimately, it comes down to what Colin just highlighted, is that you still need to make a decision about the project and the economics of the project and whether it actually just makes pure investment sense. Because this is a green card you're after the green card and you want a successful petition, but you also want your capital back. Right. This represents the life savings of many families, and we take that very seriously, that commitment, and we recognize how important that is for your due diligence process. And those same questions need to be addressed when you're comparing infrastructure, rural, and high unemployment area projects.
Yeah, and it's yet to be known as far as how USCIS is going to treat investors that sign up for multiple categories. Do you qualify as rural versus and TEA and or infrastructure, and will it carry over or cross buckets? Who knows at this point? And maybe that's something that'll come out of the USCIS engagement call. But ultimately, when you talk about like what's faster, the best way to do this, and really for a lot of our Indian and our Chinese investors that are expecting some high volumes from those countries, they think that they have to go to infrastructure or they have to go to a certain category. And that's just simply not true. It's all current right now for all categories and all countries. It's the same. So especially if you're located within the United States and you have the ability for concurrent filing, and if you were just to go heads up, if you thought one project actually had better economic prospects, if it's an urban downtown development that has a whole lot of market to it and everything else, versus another outside the box project in a rural area that doesn't really have a depth of market that an urban core deal would have, if they both had the same processing time, the same access to a green card, which one would you pick? And ultimately, sponsors and other people are going to market their own deals. They're going to sway a certain way, but verifying like there is no actual strategic difference today with a rural project, a urban or TA high unemployment versus infrastructure. They're all facing the same line today. So going from there, open floor now. So anybody that has any questions, go ahead and throw them in there, and we'll start going back up to the list of the ones we missed. But please throw things in there, and this is an open engagement. I think you even have the ability to raise a hand if you want to be on video and you want to be on what we call the stage. You could do so. It's up to you. But we'll definitely take questions now. So please keep typing stuff in. There's only 10 or 12 of us on here, so it's a small intimate group here. But talking about being able to finance the investments, there's a lot of different ways to call financing, but essentially, can you use money that's not yours to fund an EB-5 investment? And yes, you can. And Peter, if you want to take it through, or I can either way.
There's a couple ways to think about this in terms of financing your EB-5 investment. And this is actually where, what makes Behring and Behring Regional Centers stand out in this industry is that we offer partial payment plans for you to invest in stages. And most projects or other regional centers don't offer this because, frankly speaking, they need the EB-5 capital in order to start the project or to continue the project. Ours are structured in a way that we're not overly relying on the EB-5 capital to go forward. And so we recognize that sometimes you need additional time to assemble your capital, but you want to file right away, especially under these circumstances when it makes a big difference as to where you are in line for those reserved visas. And by doing a partial payment plan, it's essentially a free financing option through Behring.
Yeah, interest free.
Yeah, and so you're investing a partial capital at the time of filing. You file your petition, you get your priority date, you file concurrently if you're already in the United States, and that can help some families lock in their child's age if you had any child age out risks. If they're aging out you're in the EB2 category or the E2 category, and your dependents are on the verge of aging out. If you were to file in EB-5 and did it concurrently with the adjustment of status application, you could lock in your child's age. So it could be very advantageous to get that priority date right away. You file, and then 6 to 9 months later, in some cases up to 12, you would fund the balance of your EB-5 capital. So that's a free financing option that's available through Behring to get you started right away. The other option is more traditional financing option with our affiliate company. It's a licensed lending institution called Unity Lender, and Unity Lender can provide limited financing to help bridge the gap. So if you have some funds, but you don't have it all, or you can't source it all, you do have the option to apply for an unsecured loan through Unity Lender, typically between $50,000 to $250,000 for various rates or various terms based on your needs and your background. So this is another intriguing option or powerful strategy that can be used, and that is permitted under the EB-5 rules and accepted by USCIS.
Yeah, we got a lot of clarification with the RIA. The new policy specifically codified the use of unsecured loans in the law and gave good description on exactly how to use it. Whereas before, we were kind of working backward, where we had the USCIS and adjudicators manual. Then we had to rely on court case decisions in the John case and kind of extrapolate what a judge would do and not do. And the idea that a judge said cash is cash, whether it's a loan or not, it counts as cash, and that would work. It was a little murky, but now unsecured loans specifically were codified in the RIA. You do need a source of funds. So the lender, and in this case for us, it's Unity Lender, does provide the source of funds package to substantiate the cash and where it came from, and that's lawfully earned and used. That all works. So if you're taking unsecured loans from family or friends and other people, and unsecured loans can be better than gifts sometimes because of the taxation and depending on where it's coming, and if there's gift tax in the country of origin or from the giftor, sometimes an unsecured loan is a better option. So gifts are always a very popular item as well, from family to younger family members that maybe early in their careers and have not amassed $800,000 in order to invest. So when you talk about, can you finance an EB-5 investment? Yeah, you can, through the installments and partial payment plans, through unsecured loans, and also through gifts. Those are all ways to accumulate the $800,000 or the principal investment in order to satisfy USCIS regulations. So yeah, there are abilities for that. Next question.
Yeah, just someone is asking about a little bit more specifics on the partial payment plan. So just to give an example, you would invest a minimum of 25% at the time of filing, generally, and then you would file. So 25%, 200,000, or roughly speaking, at the time of filing. You file the I-526E petition, and then 3 months, 6 months, 9 months later, whatever is feasible for you, you would then fund the balance, 600,000. And then when you do fund that balance of 600,000 and complete your investment, your lawyer would then file a supplemental source of funds report with USCIS to complete your I-526 petition. Now, if you timely complete your partial payment schedule, then this is not going to have an impact on your immigration processing. If you delay and not complete it on time, and too much time passes, USCIS could pick up your file and then send you an RFE, and then you would have a limited time then to complete the investment and document it and get it filed. And that can delay, right? If you got an RFE, that would unnecessarily slow down your processing time. So if you do it and you do it properly, it's going to give you this advantage and enable you to file sooner without impacting your overall processing time. And by doing a partial payment plan, it doesn't impact your concurrent filing option. So if you were in the United States, you file, you fund initial capital contribution of 200,000. You file your I-526E petition. You'll still be able to file your I-485 adjustment of status application and get your work authorization and your advanced parole. So you can still do that with a partial payment plan. So that is, I hope that clarifies the procedure for you.
Yeah, and the fact that you're able to do the concurrent filing with partial capital contributions, essentially get the benefits of the green card without even having to pay for it yet. It's just a substantially less cost opportunity to essentially get to the process of EB-5 and to get to the really the benefits of the green card. That's a massive increase and a massive improvement from the world of EB-5 that was before. So big time changes there. Talking about the Unity Lender does not only do loans for 1 year. It's actually based off every single applicant. They essentially just need to provide the ask, how much principal and for how long. Then there's a spread of terms and interest rates, as well as income requirements and other things. It's like any loan that you're taking out from any banking institution. It's largely the same credit risk and the same credit review in order to want to approve and issue those loans. So Unity Lender is pretty flexible, but as Peter mentioned, the principal amounts are typically that $250,000 and under. Only under specific circumstances are you going to get loans that are larger than that. Plus, Unity Lender might not be the cheapest source of capital. Sure. It's really supposed to be a plug and a fix for very unique situations in order to accomplish the EB-5 investment. So, if you're looking at home equity lines of credit, or if you have other access to capital on mortgage and other things, sometimes that money would be cheaper. But, again, in 2022, the markets are changing. Interest rates have gone up. It is a little more difficult today on funding real estate. So the Unity Lender actually has gotten a lot more phone calls as those rates, unfortunately, the rates on Unity Lender didn't change, but the bank rates sure did. So that has become a resource that people have needed here as of late. How long do you have if you do these partial capital contributions? It's that question came in. It's a moving target, because it's really, like Peter said, it's based on when USCIS picks up your application. They send you an RFE and say, hello, great. We received your initial capital contribution. Please show us the contribution of the remaining funds and the source of funds that goes with it. And you have 90 days for that RFE to respond to it. Yeah. Then if there's something deficient with the RFE, they're going to pick it up. They're probably going to review it on their side. It'll take them another 60 days or so in order to get you another RFE, and or a little bit scarier is a NOID, which is the notice of intent to deny. They're essentially telling you, like, please give us the real answers we're asking for. And then you have another 90 days. So in the event that for whatever reason you did initial or partial capital contributions, and then you needed to buy yourself more time, the pure back and forth of the RFE, the NOID, and the responses, you probably could scratch for another 6-7 months back and forth before you'd really actually get hit with a denial. But that's only on the immigration and the USCIS processing side. And that's like the absolute worst case scenario that you would ever need to allocate that kind of time to recovering your plan for funding the investment. The other one is the needs-based investment of the project itself. Even though you're doing partial capital contributions and installments, the project itself is still working on its own timeline, its own construction path, and that's how it's creating jobs. In some circumstances, some projects are going to finish their construction before your money hits, and depending how that project was set up and how it was structured, that might be the deadline for when you were able to actually contribute capital to have it used for job creating purposes to get that credit for your 829, which in the end is the only thing that matters, because that's where the ultimate permanent green card comes from. So there's a couple different variables that will tell you how much time you really have for paying the partials and everything else. And it's a moving target, but always you can inquire with your regional center. You can inquire with your immigration attorneys. They will always be able to give you really good windows and targets that will keep you on track. So again, the partial capital contributions, the unsecured loans, these are kind of our advanced strategies. Yeah. These are not normal EB-5, which means that you need professionals and guidance on people that have done it before and been approved. And I don't know how many of these we've done, but with the partial capital contributions, 100% approval across the board. It's completely okay. USCIS doesn't look at you wrong or think less of you if you put in less than 800,000 to start. They don't take it personally, but you want to do it right. And the source of funds package, as well as the documentation that you're getting from the project and the regional center, pivotal to getting a very, very smooth approval. So
and we
very important.
We want to put the best case forward for you to USCIS. And so these plans, whether it's an unsecured loan or a partial payment plan, they do need to be structured properly and carefully. And when it comes to source of funds, and there's a question here I'll get to about source of funds, it's a very important, whichever strategy you take with your source of funds strategy, that you work with a very experienced EB-5 immigration attorney. And if you need referrals, we can refer you to some of the top immigration attorneys in the industry, very, very smart and very adept at identifying the best source of funds strategy for you. And they're usually available for a free preliminary exploratory call. And so we encourage you to, if you haven't already, talked to one of us or one of members of the Behring team to schedule a what we call a EB-5 planning session or personal investment planning session. And we'll walk you through your questions on the process, on the requirements, as well as the source of fund strategies, and give you referrals to immigration attorneys, and of course answer your questions about the project and about your investment options.
Yeah. Getting a question here, generally asking about income. So if you're taking these unsecured loans and you're paying interest on borrowing money to fund your EB-5, is your EB-5 investment going to produce enough income or cash in order to pay for those loans and essentially make that loan free? And that turns into a investment question much more than immigration. And it depends on the terms of the investment that you're going into. If you had a higher yielding, higher income, and higher profit project that you had signed up for, and it's probably going to be in the form of common equity or a high yielding preferred equity of some sort. A lot of EB-5 deals are on the lower risk, lower return spectrum and loan style investments. So it really depends on which asset you pick. Then again, please keep in mind with reward comes risk. Risk and reward are typically correlated. And as soon as you go into the high yielding EB-5 investments, they're typically different animals. And like we've seen some of those that are on the market, but our option that we created is our legacy fund, which actually has common equity and preferred equity. Those are true partners, people that are coming and taking the risk, taking the ride with us as development owners and limited partners, and people that are invested direct in the real estate that we're building. And that's the legacy fund. And we have those options, which are higher earning. But from a cash flow perspective, when you have development deals and you have to build them, you're going to be under construction for a number of years where it's not paying out cash flow because the apartments and the property is not finished. It's not leased up. There's no people. There's no cash flow. So don't expect a project that's not built yet to produce cash, because if they did that, they're doing that out of what they call capitalized interest reserves. What that is that they expect to pay cash on a loan, and they put that money in the budget already with the expectation that throughout the duration of construction, they're going to pay a fixed return out as a loan to the lender. So what that does is it actually adds more budget and more risk to the project, because you've essentially taken the investor's interest, which is call it the lender's interest in this case. You've taken their money, put it in a bucket just to pay them, and you've essentially taken their money up front just to pay them back, and then you have to pay income taxes on all that earnings. And when you have interest expense, and for you as the call it the lender, it would be actually ordinary income. All of that cash flow is taxed at the highest rates in the U.S. tax code. So why would you want to invest somewhere just to be paid back a highly taxed income? Essentially, you're kind of losing on both sides. The legacy fund accounts for these items. Our tax structures and our ownership structure pushes everything to the lowest possible taxable categories on purpose. And then when you own these properties and they're cash flowing, we also benefit from the depreciation. These buildings on a 27.5-year schedule, the depreciation shields the income, and you can earn a tremendous amount of rental income and not be exposed to taxes because of depreciation expense. It's a little bit outside the realm of EB-5, but it's something that we talk about a lot on our real estate investing videos and our real estate investing seminars. And we're having one tomorrow if people are interested. It was in the email that was provided earlier with the office hours, but that's where we start talking about the really advanced investing mechanisms and strategies that we use outside of our EB-5 world as well. So again, like, the EB-5 world is big. It's massive. It includes a lot more than just a green card, but happy to talk about all of it. All right, you go ahead.
Sure.
I just
I know
spoke a lot.
There's one question we overlooked. One was, and it's on this topic of partial payment plans, unsecured loans, and source of funds generally. So whether or not you are getting an unsecured loan or a gift from a third party, such as a family member or a friend, who are helping you finance your EB-5 investment, you would need to, that person, the donor or the lender, would need to provide source of funds documentation, just as if the funds were coming from you directly. So that includes 7 years of tax returns, bank statements, just whatever the case may be, where those gift proceeds to you, where they're coming from. So if they're selling a house to finance a gift to you, then they would need to show the documentation of the ownership of the house, possibly possibly also the cash they use for the down payment to purchase the house, and so forth. And then the actual documentation from them to you is quite simple, and that's usually prepared by the attorneys. That's a gift affidavit or an unsecured loan. And but it does, especially if you go in the unsecured loan route from a friend, you do need to work with an experienced immigration attorney to help you structure that properly.
Yeah. And then when Peter mentions, gift affidavits and documents and evidence and things like that, experienced attorneys will give you a straight roadmap on exactly what those are. And, the best and most convenient service providers are actually going to give you the form template. Yeah. So this is not something that you need to go searching all around trying to figure out all on your own. Typically, these are services and benefits that you're going to get out of working with good law firms. And we've worked with probably 17, 18 different immigration attorneys across hundreds of investors. It's a very competitive industry, and a lot of them are, very good. But there is definitely a few that you would consider industry leaders, depending on your case and how complex or sophisticated and how simple. You have a lot of choices. So, any more questions here? Yes, I think we do.
What is the difference if you apply in the United States or in Canada? So this gets into immigration strategy. So you're going to want to have a sit down talk with your immigration attorney to have specific legal advice about your immigration goals and your personal situation. But generally, the difference, I think the most fundamental difference would be the ability to proceed with concurrent filing. So if you are in the United States at the time that you file, or when I say file the I-526E EB-5 petition, or you file and you later enter the United States on a valid visa, then under both circumstances, you may be able to apply for concurrent or apply for adjustment of status. This is the new concurrent filing option available through EB-5. Concurrent filing generally is nothing new under the immigration statute. It's available in other visa categories, but it is new to the EB-5 category. So if you were considering filing from Canada or filing in the United States, that would be one distinction to consider. And it just depends on your own personal goals. Because if you do enter the United States and you're filing for concurrent filing with the adjustment of status application, and likewise applying for your work authorization and your advanced parole, you're going to have to stay in, unless you have a dual intent visa like H-1B, L-1, and so forth. You're going to otherwise have to stay in the United States until that EAD and advanced parole come through to enable you to travel. So there's a lot of factors you need to consider. It requires close conversation with an immigration attorney and legal advice. But that's one of the main distinctions you want to consider. Having said that, I do want to just clarify. If you file in Canada and then come to the United States and it's technically on a B1, B2 visa or something, a non-immigrant visa, a non-dual intent visa, then you do need to have a close conversation with your immigration attorney as to when and if you can file your adjustment of status. Because it's a much more nuanced conversation if you're considering that approach.
It also opens up the ability on the TN visa.
Yeah.
So TN visas, being a little bit faster, a little bit more convenient, a great strategy for doing the concurrent filings and switching to EB-5, because it is a qualified visa that can do that much more than a tourist visa and or a temporary business visa, B1, B2 of the like. There are still extenuating circumstances where other visas can fit the category, but it's definitely only under certain special circumstances that USCIS will look at it favorably. And that also comes with an extremely experienced immigration attorney to adjudicate exactly what the risk and reward would be of doing that. But for certain groups, that concurrent filing and the immediate adjustment of status is so valuable that it's absolutely worth looking into. So,
and again, if you need a referral, as part of our free consultation call about the EB-5 program and Behring's EB-5 project and investment options, we can refer you to several immigration lawyers that are industry leaders and able to have that conversation with you.
Yeah. One question that we had much earlier on, I'm sorry we didn't get to it, but there was a question about having EADs pending and one person out of a family receives the EAD and the others do not. And the question is asking whether there's any sort of special USCIS policy behind something like this. And Peter, unless you feel differently, there is unfortunately just a level of luck that goes into receiving certain petitions at certain times. And unfortunately, it's much less science than you would hope to believe. Sometimes every now and then, like when we get the transcripts of some of these lawsuits, and we're participating also alongside our investors in certain mandamus cases, in those mandamus cases, which are essentially federal lawsuits suing the government to pick up a petition and adjudicate it, you learn tidbits from the government on how well their processing is going. And unfortunately, there's a lot of randomness to how well, how quickly, and who gets adjudicated. And we have certain videos on the YouTube channel that talk about the randomness of pulling petitions out of the mailroom, because sometimes they'll pull the one that is closest to the door rather than the one that's next. And not a great system, but it's all we've got. So maybe someday we'll change. The electronic filing lasted how long? Yeah, a couple of weeks, I think. They had electronic filing and it worked great and then disappeared. Every other business in the world figured out how to work in the cloud, but instead we're still sending boxes of 1,800-page I-526E filings and moving forward with that. Quick question, we're starting to lose a couple of people. Like, was this useful? The office hours, having direct access, direct Q&A. If you guys appreciated it, please throw in a message. And the feedback's great for us. And if there's any topics that you would love to hear about in the future, we can definitely prepare more material. If there's anything else that we can address, we would love to do so. But we hope this was an event that you guys found useful, and we will plan on doing these in the future as well. So if you have anybody that is interested in EB-5 or learning about it, just send them the registration invites, and we'll be up here as of right now planning weekly. So we appreciate people joining. And if there are more questions, we're happy to stay on and keep answering them. We do have a little bit more time. So we're here.
Did you want to give an update on Return Broadway? Yeah.
So most of you are in communication. I guess I could have used these prompts earlier, but I guess not. But update on 1900 Broadway, our EB-5 project that's currently going, showing, some of the people on the call here today are actually investors already. One of our quarterly updates that we typically do, we pull a great photo report just showing the side-by-sides of the renderings versus the actual and on-site photos. And as you can see, 1900 Broadway is coming. We're already on the 21st and pouring the 22nd floor here this week. Crane is getting taller. We're jumping it 2 more times here. Once last weekend, and we got 1 more to take it up to 400 feet. But you can see, the rendering is really starting to come to life, and it feels really good. Over 1,500 jobs have already been created just through the construction alone. A lot of progress being made. Construction-based jobs, still the best way to go. You can guarantee that they actually happen just by spending on the construction. It's a controlled environment. You're not subject to operational risk like you would be in something like hospitality and hotels or resorts, restaurants, things of that nature, where they come and go in economic cycles. Construction happens once, it's guaranteed, and you can account for the jobs very, very easily. 21st floor, Peter and I were up there looking at the decks and the concrete. That is a view of San Francisco. We're about halfway up the building, and we have a straight shot of the entire scenery from downtown San Francisco, Salesforce Tower. And then if you turn 90 degrees to your right, you're staring all the way to UC Berkeley and the Berkeley Clock Tower, unobstructed. So, we joke because, the best views of San Francisco are actually from Oakland. It's not in the city of San Francisco itself. So everything is just going to plan here for 1900 Broadway. Got our first couple floors of the curtain wall glass facade, all this kind of stuff. Starting to see that construction spending really tick up as more trades are entering the building. Everything mechanical, electrical, plumbing, the drywall, and now the exterior facade. You're really starting to see that top of the bell curve where more jobs are being created every single month. And at our peak, we're looking at this project probably creating 140 to 150 jobs a month at the peak cycle, which we're approaching here pretty soon. So for EB-5 investors that just kind of wonder about the simple questions like, have my jobs been created yet? These are the kind of projects where you're getting a lot of very quick, efficient, and guaranteed job creation, and it's tangible. You can see it, and you're not going to lose it. It's not operational jobs that come and go with cycles, hiring and firing. You build it once, you get credit. Best way to do EB-5. Yeah, just more shots, concrete, glass starting to go up. Very proud. It's been a long road for the development and for the investors, and like it's really starting to come together now. Also, I mean, we didn't add any of the slides on it, but this thing is as mature and as simple as it gets. I-526 approved, 924 exemplars, the 956s were filed. The job creation is already in process. The bank loans are already in the project, signed, secured, fully funded. This thing is on a straight shot to completion, and right now is really its peak maturity and the best possible scenario to sign up for, just because a lot of those risk factors, those boxes have already been checked. They're already complete and they're out of the way. So you look at other projects and they haven't even started yet. That checklist of due diligence that the regular lender is going to do is probably 7 pages long of 10 font. So, you know, when you're looking at something that's already this far along and has already made this much progress, the only reason it's truly available is because we're a dedicated EB-5 developer. We're fully integrated top down, where we make our projects available to EB-5 investors as much as we possibly can. And other developers that usually treat EB-5 capital as second rate or second position or not as priority, as soon as their development's funded, they stop making opportunities for you to join. So ultimately, you know, by being with a group that's truly dedicated to its EB-5 platform for the long term, we know that this is the point where the risk is at its lowest. This is the point where this is the best an offering can get. And we're going to fill it out according to job creation elements and everything else. And, you know, this is what we found to be our truly most successful strategies. So it's 1900 Broadway, and, you know, more information to come.
And just on that, one highlight is that this is the qualifies for the high unemployment urban visa set aside category.
Yeah, so just as qualified, just as fast as any other category. It's no different. There isn't a better category as long as every country remains current for the high unemployment category and high unemployment reserve. So, you know, despite what anyone's trying to sell, this is as good as it gets. And, you know, we're here to try and make sure the correct messages get across. So if there's not any more questions, we will conclude today's session. But anything else that we have, or anybody want to just last call for EB-5 questions for today, putting September 15th in the books here.
You may answer this. I was just about to type this one here.
Okay, well, you can answer it.
Yeah,
you answer it live.
Some questions are asking about the investment period, and so it's typically 5-year investment period. The trigger date, you know, in terms of EB-5 eligibility, is that you've had your conditional green card for 2 years and that you have filed your I-829 petition. And so the question I was getting is, well, does that period fluctuate, or is that dependent on, you know, like when my petitions are getting approved? And yes, so if it is, like the I-526 petition for some reason was taking longer, or maybe you got your visa from China or something, and you're an investor from China, and your sustainment period, your 2-year conditional residency period took longer because you're waiting to get your green card. Those are factors that could stretch out that 5-year period because you're waiting to qualify and file that 829. Now, couple points on this. One, if your I-526 petition has been lingering, you know, beyond 12 months or maybe 12 to 18 months, then you could talk to your attorney to see if you're eligible for the mandamus strategy. And this has been a very successful approach to pushing USCIS to do its job and to process these petitions faster. So we have seen success industry-wide, but even in our own investors have been able to get their petitions approved within 30 to 60 days of filing this mandamus action. So that can speed up the process for the I-526 approval, or even the adjustment of status, I-485 adjustment of status approval. But typically the lawyers are waiting for you to have been 12 to 18 months after filing your petition. So that's one approach. The other comment I would make, if the investment period is lasting longer because you're waiting for the filing of the I-829 petition, and this is again what makes Behring unique, and especially with our legacy fund, as Colin described earlier, that it is designed with this built-in safety mechanism in mind, that if you are investing in a longer term because of immigration or retrogression, then the legacy fund has the liquidity options for you to be able to redeem some or all of your investment while still leaving in your required capital investment to stay eligible for your EB-5 green card. So it does have this ability so that you can actually cash out after 5 years any of your gains while still leaving the capital invested in, so you still get qualified for your permanent green card. So that's we can go into more detail. Actually, tomorrow you'll probably talk a little bit about that in our legacy fund webinar, and in future videos we'll walk through these redeployment and retrogression strategies with legacy fund.
Yeah, and there's a big difference with USCIS where they don't let you take out the initial $800,000 capital contribution until the end of the sustainment period and right when you're filing that I-829. But they will always let you take profit. And that's what Peter's talking about, where if you have a high earning investment like the legacy fund's common equity units, which is just like a limited partner, an investor of real estate, if you doubled your money, you've had $800,000 investment and it turned into 1.6 million. You could take all 800,000 of the profit and you can take that out of the deal, and it's essentially getting your money back. And then the rest of it, your initial 800,000 is still there, still qualified, still able to get the green card, but you did recover your initial investment. USCIS allows that. There's not a lot of programs. There's not a lot of EB-5 opportunities that target this kind of return or even have the ability to, because without a Behring style approach where we're the developers, the investors, and the EB-5 platform, there's no way that can be made available to you without a legacy fund styled offering. It's just the sequencing is very difficult, having equity first and then being able to build a project and then having the EB-5 debts later. Because of our integration and our 10-year history and our capital resources and everything else we have built this machine for the long term to serve all kinds of different levels of investment and people from different countries with different schedules. So like this is the culmination of a decade of work. So, on the equity side and those common units, much different than what you'll usually see on the market with these low interest debt style investments. And unfortunately, if you end up with a lot of retrogression and backlogs, which the Chinese, Vietnamese markets hit 2017, 18, you still have that same schedule with no profit. Yeah. So one reason why the legacy fund was built, as Peter mentioned. So a quick question that we have, what's the difference between investment and capital investment? Really, it's nuanced. In some regards, there's zero difference. Cash is cash. If you invest cash into a project, it's your investment, but it's also your capital investment. But capital and the investment, it can also take different forms. Sometimes it's not cash, and some people are contributing equipment. Some people are contributing other resources or other things of tangible financial value. You don't see it very often in EB-5 where somebody is producing some sort of capital investment that's not cash, just because cash is so simple. It's also potentially adding a level of complication for your adjudicator, because all of a sudden you contribute a whole bunch of, call it construction materials that has a certain dollar amount. The USCIS adjudicator now needs to go find out what the market value of that commodity happened to be. Was it aluminum, steel? Was it a manufactured and improved product? Now you're adding a little bit of complication, and that adjudicator is already dealing with a lot on his plate and is probably not asking to become a commodity specialist in the process. So cash has always been the easiest and most popular form of capital contribution. But, in certain situations and more sophisticated outfits, you could contribute something besides cash. So you're going down a deeper rabbit hole there, but like you are right. There is a difference. It's nuanced, but in some situations, if it is cash that you're talking about, it is the same. Investment, capital investment, same thing. There's also a difference in definition when you're talking about, who is the enforcement authority. If you're talking about tax, it would be the IRS. They would look at capital investments differently because it's a tax classification of how it goes in and how it comes out and what it would be taxed as. Is it depreciable? That's a difference. So that's another nuance, is the difference between, are you talking to SEC or a bank for lending, or are you talking to the IRS? They would actually have different definitions for each of those. But again, a little bit outside of the EB-5 realm, but for the purposes of USCIS, the safest definition for both of those is probably cash. So hopefully we answered that question.
Yeah, I think we got most of the questions. If we didn't get anything, I'll just put my email address, I guess, in the chat, and folks can email me.
Email Peter.
And then we can answer your follow-up questions. But we'll be here next week too for our office hours, and hopefully answer your questions at that day too.
Yeah, so every week, currently scheduled 2 p.m. every Thursday, Pacific time. And we enjoy answering these questions. We enjoy learning from you guys too. So bring your questions. And if you're out there researching EB-5, something doesn't make sense or it seems questionable, bring it in. Bring the questions, because we want to talk about it and get it straightened out. And also, we learn things in that process too. So thank you for joining today. And if you need us, we will be here next Thursday. So thanks again.
Thank you.
Thanks, guys. I guess we could ask, is there any last questions before I push the red button? Just because we're seeing some things come in. So, but thank you all, and we appreciate it. All good?
Sure.
All right. Thanks, guys. Maybe that's not the button. Still, where is the button? Does anybody know where the button is? There's a button. See you guys.